Welcome to the Expert Network Team podcast,
where our goal is to inform and educate our listeners on matters related to finance, legal, insurance, accounting, and other interests that are of personal and business nature.
We hope you will find our content useful as well as entertaining.
The Expert Network Team consists of Karl Frank of A&I Financial, Mike Miller of Miller & Associates CPAs, Jeff Kromendijk of Security First Insurance Agency, and I'm Nathan Merrill, an attorney with Goodspeed Merrill.
Together, our independent team combines our expertise to provide you insights and solutions, some of them straightforward, some of them opaque, for real-life opportunities we see on a daily basis. We hope you enjoy the information contained in today's podcast and find it useful. If you'd like to learn more or desire to meet with any of the Expert Network team members in person, you can contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
We encourage you to take advantage of a free consultation with any of our team members. Just mention this podcast when you schedule your appointment.
Now on to today's podcast.
All right, welcome to today's podcast. I am actually quite proud to introduce today's guest because he's part of my team at Goodspeed Merrill. This is Nathan Merrill, and I have with me today both Karl Frank and Jeff Kromendijk.
Hi, Nate. Hi, Jeff.
Our subject matter expert today is John Sauer, and John, like I said, is from my team at Goodspeed Merrill, and he is specifically in the employment law practice and crossovers with litigation there. John, welcome to today's podcast. We're really grateful to have you here.
Thank you for having me.
The topic we're going to discuss is an interesting one, and a lot of our conversation has, in prior podcasts, has circled around the impact of COVID on our lives. It's hard to have a conversation with anybody anymore without the issue of COVID coming up. But today's issue is going to hopefully give us some more clarity and guidance and understanding of the COVID issues we face as employers and how we should be prepared to handle workforce issues, employment issues that arise in relation to COVID. So, John, I'm going to open up the questioning here by just having you kind of explain in maybe broad terms, where have you seen the biggest impacts in your area of practice since the advent of COVID? What's changed the most? What should people be aware of that has really kind of come out of the COVID era?
I think the scariest part about my job now is that I really become a frontline resource for employers and businesses that are going through a COVID outbreak. I haven't, in my practice, spent a lot of time on the phone between the hours of 9 and midnight. Since COVID, I spend a lot of time on the phone with clients that are dealing with, well, what do? I have one employee that tested positive for COVID, and my other employees are freaking out. How do I handle that situation? In addition to that, there's an enormous amount of regulation that has come out. There's an enormous amount of changes with respect to law and obligations on employers and businesses. And simply getting up to speed has become its own specialty. Are you an employment lawyer, or are you an employment lawyer that knows and understands the COVID issues? Because those are two very different things, and almost everything with respect to federal leave laws has changed or been amended, especially under the FFCRA and under the ADA. What obligations are on employers now it's much different. And I mean, they're still the same in the sense of you have an employee that has a regular disability, but in terms of COVID, some interesting questions that come up are, I have that one employee that has COVID. Can I tell my other employees to, not go in the break room because Susie has COVID? How do I address that?
Got it. And so where would you, if you were to prioritize where an employer starts when responding to either going back to the office if they haven't already or going back to the workplace, where would you recommend they start in terms of prioritizing getting stuff into place?
One of the nice and convenient things about the way the regulatory scheme works right now is that The federal government has put in place basically the least specific requirements. And so when you look at the CDC website and you look at the obligations that OSHA has put in place for employers, those things are extremely general. OSHA says try to make sure you have a safe workplace. There's a lot of guidance around what that means within OSHA, but it's not nearly as specific as when you get down to the state regulations within the public health orders that have specific obligations for employers and businesses to follow when they have employees. And then you have your local health authorities that on a county-wide basis here in Colorado as to what those obligations are. So in terms of starting, the shortcut is to start with the state regulations and then look at what additional local regulations there are with respect to how you handle employees and how you handle return to work and what issues you need to monitor specifically under those regulations. And then work on developing policies and procedures. I think the state of Colorado has done a great job in terms of providing really kind of here's how you deal with this situation guidance in the public health orders. One thing that they require is the deputization of a COVID manager. So if you have a business and you've got 10 employees, you need to deputize somebody to deal with all of the COVID issues and get that person in touch with an employment law attorney, make sure that person's read the public health orders, make sure that person's aware of the screening obligations, make sure that person has authority to close an office kitchen or something like that.
So I'm going to interrupt you there real quick. What does it mean to deputize someone? I mean, are they getting a badge?
You guys were thinking it too, right?
I was, totally. I know who that person is in our office, but I haven't deputized that person.
You haven't bought the badge yet?
I haven't done that.
You don't need no stinking badges.
Yeah.
That's an artifact of it being something that comes out of state government, I think. Just tell somebody, here's your new job title and here's your new job duties with respect to that.
So I'm asking a question on behalf of Jeff here. Does that individual then take on specific liabilities or duties that could impact that individual, or is it mostly titular in nature that they're?
I'm not sure what that.
Like
word
if they
means.
don't do meaning it's just a title they're given and they don't take on any particular. If they don't do their job, do they have personal liability? Like if they're deputized as the deputy of COVID, and they don't actually properly follow through with the screening or that sort of thing, and someone comes down with COVID, do they take on any personal liability by virtue of accepting the deputization?
I don't think they take on any personal liability unless they're doing something well outside, essentially, the cover of the corporate entity.
Okay.
They do, on that level, in the same way that an HR manager is going to be deposed in employment litigation because of a decision to terminate, they could be subject to later, court proceedings and have to testify with respect to what measures were in place to prevent the spread of COVID in the workplace.
So they do take upon they're representing the company in their role as deputy. And if they don't do it well, then the company could take on liability for failure to properly deputize someone.
Yes, so that's another issue that comes up a lot. I mean, as soon as COVID hit, there was a serious panic amongst employers and businesses generally as to what liability they could have with respect to the spread of COVID. And I think that, frankly, what's going to happen in the next COVID package from Congress is going to be some version of a liability shield. At this point, the proposals seem to circle around. There will be a liability shield for businesses so long as they're able to prove that they complied with applicable health and safety codes for their business, or at least put in place a gross negligence standard. So if you have, this doesn't seem like actually a plausible situation, but if you deputize someone to be the COVID person and they don't actually look at the public health orders and they don't actually follow through with putting hand sanitizer in the right places and they don't actually enforce closing doors or people wearing masks, if those are all obligations within the current public health order, that might be considered gross negligence and it might give rise to liability to the company.
That sounds scary. That's a big deal. So tell me about that. So if I've got an employee who has it, I've got HIPAA rules I've got to follow. I can't run around and say, hey, that person's got it, right? I can't violate that person's privacy. We've got like dueling mandates we've got to follow. How are you going to manage all this?
So you're right. You have an obligation under the Americans with Disabilities Act and HIPAA kind of with respect to what information you can share with respect to medical conditions that are faced by your employees. The guidance that I provide to employers in that situation is that as long as you don't identify the employee and you're as vague as possible with respect to who that person is, you're covered. One thing that happened recently is an employee came down with COVID, tested positive, and panic ran through the entire business. All of the other employees didn't want to come to work because they thought they had been, the whole workplace had been contaminated. And the girl had posted on Facebook, I have COVID. And under those circumstances, the person has outed themselves and the employer is covered, in my view, from saying, okay, yeah, Sally has COVID. We've spoken with her, or we've investigated this. We determined that she was not at work during the time that she was contagious, or she was at work during the time that she was contagious. We've now closed her office off in the break room for 72 hours, and we're after 72 hours, we're going to send in a cleaning and sanitizing team to clear that off. If there's any other health or safety concerns, let us know. I mean,
that sounds very reasonable.
Yeah,
Right.
let's stay on that topic. I think it's only a matter of time before just even the three employers that are represented here are going to have a situation where we have a positive test. And so in your opinion, John, just based on, the law, the legal side of things, and just even best practices with regards to being caught up to speed on Tri-County Health's information, what the city of Denver and Colorado and certainly the nation is conveying, what would be the best protocol when we have a confirmed case? How should we respond as employers?
I'm going to jump in here real quick just to let John know also for your comfort level. We have a legal disclaimer at the end of this podcast that even though he's going to give some specific answers here, anybody listening should not consider this particularly legal advice for themselves or this podcast in any way establishing a client-attorney relationship with John. But with that in mind now, John, would you please answer the council's question?
Wow.
So
That just rolled off Nate's tongue.
I know.
And I'm not even
It's
a
almost like
litigator.
he had a script.
I know he's going to clip that disclaimer, that whole thing right there, but yeah, maybe not.
Well, to answer your question, I mean, the typical advice is, number one, talk to the employee and gather information. They're often, ready and able to provide information regarding their own contact tracing. Maybe my mom had COVID and now that's why I have COVID. And under those circumstances, you're in a good position to say, okay, well, we've established that the transmission occurred outside the workplace. And then you need to make sure that you communicate with other employees to say, okay, we're, everybody's doing their screening, but we're also watching it now to really make sure that we don't have any inter-office transmission. You need to figure out where that employee had been in the workplace and figure out whether that employee had been contagious at the time that they were in the workplace. I mean, one of the things that's very difficult about COVID is that there's somebody has a sniffle and they go test positive for COVID. And then you have somebody that's, in the hospital on a respirator that also has the same situation. So gathering that information to really find out where the person had been so that you can go through the cleaning protocols. The CDC has guidance on that. There's also state guidance on how long those rooms need to be closed off. And then you need to go through the communication process with your other employees to try to make sure that they're protected. There's a point at which the lawyer is no longer helpful in this situation, and you really need to contact the local health authority. One thing that I've noticed is that the local health authorities are not actually providing any written guidance. So you call the health authority, you explain what happened, what information you've gathered, they give you additional instructions. They don't send you an email saying, here are your instructions, because they just don't have the time or the resources, the capacity, or even the interest. It's not, they just don't do that. So one thing that I've been advising clients consistently is that when you talk to an authority on this issue and they give you guidance exactly how to handle these situations, you need to go into your computer and you need to write a note to yourself so that if this ever does end up in litigation or it ever does end up being challenged, what you did under these circumstances, you have contemporaneous notes as to that conversation. And then essentially you probably need to call an attorney to try to figure out what leave requirements are there. This is one of the more complicated areas with respect to the change in law. There's state law with respect to what paid leave is required and under what circumstances, and then there's federal law. And for probably 3 months of this situation, there was pretty significant gaps between state law and federal law, and it wasn't really clear whether you had to give both sets of leave or whether you only had to give one set of leave. And then those types of leave don't necessarily just pertain to whether the employee has COVID. If they're caring for somebody that has COVID, they could potentially be entitled to leave. And then if they have a daycare or a school that closes as a result of COVID, under those circumstances, they may be entitled to leave under the Families First FFCRA. And after that, after all the emergency stuff is taken care of, you need to gather the information from the employee that will permit you to take the documentation to your CPA and say, I paid out this much FFCRA leave. Here's the doctor's notes. Here's the notes from the daycare that closed. Get me my tax credit.
Okay. So one thing that I was expecting to hear from you that I didn't hear, that now appears possibly to be somewhat of a misnomer out there, and maybe a flaw in our protocol that we've communicated with our staff, is that we would close the office for 14 days, regardless of, I guess, how they contracted it, or maybe even regardless of who they came into contact with. And what I hear you saying is, no, do more investigation. That may not be necessarily the thing that we have to do. It could be, but depending on how they contracted it and who they were in contact with and what portion of the office they were in and so on and so forth, that may not that might be a worst case scenario versus what is
Baseline.
proper protocol.
One thing that's important to keep in mind is that this is general advice, and I'm not advising you specifically with respect to your situation, but our law firm, we were able to move very quickly into working remotely.
Right.
There's still very strong guidance that everybody should be working remotely to the extent that it's feasible. That hasn't let up at all. So if you're in a workplace where working remotely is okay and functional and you can still carry on business, by all means, close for 14 days. I think one of the more permanent changes that COVID is going to have on the workplaces, who needs an office? That's one of the biggest pieces of overhead for any business. And if you can work remotely and your employees are happy and productive working remotely, why do you need an office? And
on the flip side, just to interrupt you there, the cubicle environment may be forever altered as well if COVID and COVID-related illnesses become the norm, because the closed office is obviously better than kind of the open cubicle environment, is it not?
That's correct. The current rules with respect to whether you have to wear a mask when you're working or not is whether you're in an open office space or not. So if you're in an office with a closed door by yourself, you're not required to wear a mask, and that was the latest Denver mask order. Right now, I think that you're absolutely right. The cubicle environment, the open office plan is forever changed as a result of COVID and unlikely to continue.
So I want to follow up on something it seemed you alluded to earlier, but how does the ADA intersect with COVID and reasonable accommodations and that sort of thing? If your job cannot be conducted remotely, what level can someone invoke the ADA or any element of that to adjust how they do their work?
So I've always thought about the ADA.
What's the ADA?
The ADA is the Americans with Disabilities Act, and
Thanks.
It's actually the ADAAA because it's been amended. But in this context, COVID could be considered a disability, and it could give rise to obligations on an employer to provide an accommodation. What does that accommodation look like? That's another question. So if you're in a workplace where the person can't work remotely, in my view, there are several levels of accommodation that you go through. You first try to accommodate the employee in place, right? So if you can accommodate them in their position, great. If it's giving them, a laptop and sending them home, that's perfect accommodation. State law and the public health orders also require accommodations in the same way for individuals that are considered vulnerable to
Well, that was going to be my next question is, beyond just those who have contracted the illness, what about those who can fall into that category of vulnerable individual?
So
who are those people?
Yeah, so the ADA is permanent law. I mean, it's there. The current public health orders are temporary and changing. Typically, it's somebody that has a serious health issue, whether it's
do they have a list of comorbidity type things like diabetes and?
There is a list within the public health order.
Okay.
And the starting point is age over 65, and then there's a list of particular illnesses that expose someone to higher risk. Frankly, an employee could go to a healthcare provider and say, I've got asthma, I'm concerned about being at extreme risk for extreme illness as a result of COVID. Would you please write me a note? And then that person is considered a vulnerable individual under the public health order, and an employer has an obligation to accommodate them. So to get back to the rest of your question, Nate, so you have the accommodation in place. If that can't take place, then you have to go through a reassignment process for employers that are covered by the ADA. The reassignment process is to look through what open positions are available where the person can work in that position. It can have equal or lower pay benefits and status, essentially, and then reassign the employee. And then the accommodation of last resort is unpaid leave. There's not an so if the employee, it depends very much on what the disability is. So as to whether you would need to actually pay them under the leave laws, because even if you're providing leave as an accommodation, there may still be obligations for the leave to be paid under the FFCRA or under the most recent legislation by the General Assembly here in Colorado, the Healthy Workers and Families Act.
So not to be the cynic, there's real risk that someone could invoke. I mean, it kind of gives increased vulnerability for aged employees and in terms of exposure to an employer. Is that the way I'm hearing it?
That's correct.
Okay.
There's a lot of room to be taken advantage of there, isn't there?
Yeah, and I don't want to assume the worst of people, but I'm just, when I think of, legal liability and exposure, it just seems to open up a whole new tranche of claims that didn't exist before. You had age discrimination and all that stuff before. Now it's age discrimination combined with ADA and COVID, and just being over 65 makes you a vulnerable individual. It just seems quite remarkable, actually.
I mean, I tend to see the good in people, and I tend to see the good in employers really just wanting people to show up, do their job, and go home. But I'm also a realist and have seen the FMLA abuses. I don't know if I probably shouldn't say this too specific. I'm aware of a person that took FMLA to attend the biggest football game of the year and posted pictures on Facebook and ended up losing their job because it's obviously FMLA fraud.
Right.
So there's always opportunities for wrongdoers and bad people to take advantage of the system. The solution to that is being vigilant and watching what's happening and tracking it. I mean, you can prove patterns pretty easily. if somebody has an intermittent FMLA issue and they're always taking off Mondays or Fridays, it sounds like somebody's actually just using it, taking advantage of it for a 3-day weekend. The real problem and where risk lies the most is when an employer starts making assumptions about things, a person's medical condition in the absence of supporting medical documentation. So you need to rely on your employees' doctors to provide you actual information.
And so if someone's requesting an accommodation because of being a VI, it is okay for the employer to ask for, I mean, is just being over 65 sufficient, or what other documentation can you ask for to do exactly that?
So you need to ask how they fall into which category they fall into, and if it's obvious, you've got their birth date. You don't need to call their doctor and ask them if they're over 65. But if they're saying, my health care provider said I'm at extreme risk, you need to say, well, give me a doctor's note. Those are all appropriate inquiries for an employer to make in connection with that. If the person says, I've got a disease that falls, or a comorbidity, as you said, that falls within the public health order's discussion of those things, you can ask for a doctor's note to substantiate it.
And you're covering a lot of territory here. And sorry, I'm dominating the questioning, but maybe to wrap this session up, I'd like to keep you over for another session so we can cover some of the other more complicated issues. But what if, so going with what we just talked about, now I'm caring for someone who's a vulnerable individual. To what extent can I, by extension of them, take advantage of some of these, not take advantage like abuse, but take advantage of some of the benefits that are afforded through these particular health orders?
So if you're primarily responsible for an individual that has COVID, there's leave available under the FFCRA. There's some provisions for leave under the Healthy Families and Workers Act with respect to caring for other people that have COVID. In terms of living with a vulnerable individual, there's encouragement within the current public health order to accommodate those employees. I mean, your wife's
living where you're not primarily responsible for someone's care. So you don't have an elderly mother in the home that you're taking care of, but you have someone else who you just live with, is what we're talking about here, right?
I mean, the familial relationship isn't necessarily material in terms of
Gotcha.
the FFCRA. I mean, it could be you live with an old person, mother, father, stranger that was under the bridge previous to moving in with you. There's encouragement to employers, but not a direct legal obligation to accommodate that situation.
Got it.
And just one more quick question, because this seems to be something that a lot of employers are talking about. And I think just as we observe society as a whole, is the fear and the anxiety that has risen just, in general. And we've seen some of this, in our organization. Is there any is there any thing that's from a legal perspective able to also consider that an emotional condition with regards to the fear of getting or contracting COVID that we would, as employers, need to be really concerned about?
I find those cases extremely sympathetic, and I've had to answer direct questions from clients that are dealing with the employee that doesn't want to come to work because they're afraid of catching COVID. The PPP loan process and the forgiveness issues surrounding that also complicated those issues now. Most everybody's outside the time frame for having expended their PPP money, so that layer of complexity is no longer there. But there's no protection under state or federal law for an employee that is refusing to return to work simply because they're afraid of catching COVID. There may be some exceptions with respect to healthcare workers.
Okay.
Fascinating.
Yeah.
Really good to know.
Really good.
A lot of
Well,
wisdom there.
Absolutely. Like I said, my head's kind of spinning with trying to keep track of everything we're talking about. But with that in mind, we'll close out this podcast. Really appreciate you joining us today, John. And like I said, if you can hang on, we'll do another episode and finish up some of these more involved questions, as I would probably consider them. This has been very good at setting a baseline understanding for the COVID situation and how it impacts employers. So really appreciate it.
Yeah, thanks, John.
Thank you.
Thank you.
Thank you for joining us today. Hope you enjoyed the information we shared.
If you enjoyed this podcast, please feel free to share it with someone else. And join us next time.
If you want to meet with a member of the team, please contact us at info@expertnetworkteam.com. That's info@expertnetworkteam.com.
If you have special topics you'd like to hear about, please reach out to us and let us know at the same email address. Again, that's info@expertnetworkteam.com. Thank you for joining us and have a great day.
Thank you for listening to this podcast. We want to remind you that listening to this podcast does not establish a client-professional relationship with any of the firms represented, nor does it constitute legal, investment, or accounting advice, and the views are those of the professionals only.
Investment advisory services may be provided through A&I Financial Services, and securities may be provided through Genios Wealth Management.